Thank you very much for coming, and thank you, the Future of Privacy Forum, for organizing this amazing event. I'm going to provide a brief overview to better understand courts and data protection enforcement in Spain. Spain is a country as maybe a bit smaller as Texas, but with double population. It is organized in different territories, somehow to the US and federal system. It's not the same, of course, but it remains. And competencies and institutions of government of these regions may vary, and sometimes even their culture. For example, in this slide, you can see some of these regions. I highlight Catalonia and the Basque country, who also have their own co-official language. Spain has a civil law system in general terms. So courts are organized in different territorial levels and also in different jurisdictional orders like civil, criminal, and so on. So despite our small size, our country is a bit complex. We should keep in mind that aside all of the European regulations and treaties, privacy is a fundamental right in the Spanish Constitution, and it's it has the same power as the First Amendment of the US Constitution. For this reason, courts in their different jurisdictions have already dealt with different privacy issues. So I'm going to talk first the judicial remedies against supervisory authorities, and then the right to compensation against private entities. In Spain, we have a national supervisory authority, the Spanish Data Protection Authority, which has been very active on privacy issues and was also involved with the Costeja case. And we also have regional authorities in Catalonia and the Basque country, which only has jurisdiction over local entities in their own territory, like universities, public hospitals, town councils, city councils, prisons. And we have already in place judicial remedies against the supervisory authorities' actions. And as you can see, courts involved are different depending on whether the resolution is issued by the Spanish authority, the Spanish DPA, or the regional DPA's authorities. But at the end, the last appeal is before the Supreme Court. Finally, we have also what it's called the recurso de amparo before the Constitutional Court, and it's a subsidiary proceeding. So this means that all remedies must have been exhausted once the claim reaches the Constitutional Court. The Constitutional Court only deals with the breach of constitutional rights. So let's move on and let's talk about the right to compensation. There are different procedures and courts involved depending on whether the damage has been caused by public entities or private entities. So when the damage has been caused by a public entity, administrative courts are involved, and when the breach is caused by a private entity or company, civil jurisdiction is involved. Any citizen can bring a lawsuit before trial courts in the civil jurisdiction, and through an ordinary procedure, which has an average duration of 9 months. And their resolutions can be appealed before the High Court of the province, of the territory, and it can last about 1 more year. But as you can see in both the scenarios, the last appeal is before the Supreme Court. And as I mentioned, there's also the recurso de amparo as a last chance. But there are other courts involved. As I already said, privacy is a fundamental right, and it has a transversal effect across the different jurisdictions. So as a result, courts like labor courts and criminal courts also deal with different privacy issues. For instance, in Spain, for example, employers that use video surveillance systems or other technical means to monitor employees in their workplace should comply with the strict requirements of information to their employees, and also comply with the proportionality principle. Otherwise, these means cannot be used as a legal evidence in labor courts, for example. And termination of employment can be considered unfair dismissal. On the other hand, in the Spanish criminal court, it establishes that it is a crime the discovery and revelation of secrets, including wiretapping, sound, image, emails, and other communication signals. Even public authorities need to comply with it. You usually need a warrant to all of these. And penalties include even imprisonment of 7 years if there's a profit and the information relates to minors or it's sensitive information. So finally, I wanted to highlight some aspects of the civil process, of the judicial process in general. Domestic judgments are automatically enforced at the same court that issued in the lower level. The way to enforce it is through an enforcement claim, which is another procedure. And when the foreign judgment comes from another country belonging to the European Union, the enforcement of the judgment also is automatic. However, the cooperation between court member states requires significant time and resources because everything needs to be translated and it takes some time. Legal expenses of these processes are not affordable for everyone. And also in Spain, we don't have a class action as strong as you have in the US. The closest thing we have is an action for injunction that can be brought by, before courts by consumer associations. But this procedure has its limitations, and it really needs to be improved in order to be considered an effective judicial remedy. And also, it's worth noting that the Supreme Court already ruled on non-material damages relating to privacy issues. Early this year, in April, the Supreme Court issued a judgment where it was submitted by an individual who claimed damages against 3 different search engines. It was a similar case like the Costeja case. And the procedure started before the civil courts, the trial courts, and went higher up to the Supreme Court. Here, the plaintiffs initially claimed $5 million for damages, but the final decision only recognized 8,000 euros for non-material damages, because it was an amount that the court estimated fair, considering the timing and the specificity of the case. However, this amount barely covered, or did not cover for sure, the legal expenses to go to the Supreme Court. So it's something that we should keep in mind. There are other resolutions of the Supreme Court evaluating damages, and I will be happy to discuss with you later. And to end, I just wanted to provide some proactive recommendations to companies that want to operate in Spain. It's very important that contracts between controllers, processors with your clients or providers should be well defined in order to avoid liability and legal expenses that may arise from citizens, because they can claim together both with the new GDPR. Be able and ready to demonstrate compliance, as it can be a priceless evidence before courts. And privacy programs should be comprehensive, should have a comprehensive approach, including criminal risk analysis and even whistleblowing systems that complies with the GDPR. And finally, establish effective internal dispute resolutions procedures as a first step, because it is conceived very positively by courts and demonstrates good faith. Thank you very much.